Hello, hello, and how are you? What a beautiful day in New Jersey, and I am sitting in the park under the tree. No, I'm not, but this year we have to joke more and laugh more because it's full of this pandemic trauma, worry, anxiety, and people, as we hear, getting sick, dying, and worrying about what's going to happen to them and to their loved ones. So, what we're going to be talking about at this point is very important: having a will. And I have to bring my dear friend, Judge Cass Sunday, to the picture. I am very happy that you agreed, Cass, to join me and shed some information on this whole will thing, which I really don't know too much about at all. But you, as a judge, you're doing this for people, right?
Absolutely.
So
Uh,
would you please first introduce yourself because you know best who you are.
well, the last time I checked, I'm pretty sure who I am. But that being said, my name is Kaz Sunday. Actually, Casmir is my full first name. Almost no one other than my mom would refer to me as Casmir, though I do answer to both. Just a quick little history. Grace mentioned I'm a judge. I'm actually a municipal court judge in a borough in New Jersey. And although we handle traffic matters and a certain level of criminal offenses, my private practices consist mostly of estate planning, estate administration, and recently I've been getting further into real estate transactions. So that being said, just a quick background. I have a bachelor's degree from the University of Scranton in accounting. I have a Juris Doctorate from New York Law School, certified public accountant, and I've taken classes and a diploma from New York University in financial planning. So I like to say I'm pretty comfortable doing cradle to grave with my clients. And if I, don't know something, I'm happy to refer business out to colleagues that are more adept in certain particular areas. So that being said, I think we should begin the lecture. And the first thing I want to point out is this is a very difficult or complicated subject matter. It takes years to get an expertise. I'm not going to give you the equivalent of a law degree education, but the purpose I want to instill in you is what to ask for when you go to your personal attorney for information. If you want a will, you want to speak intelligently with him. If he's not going to take the time to take it step by step, you want to know what's available out there and help him help you. So that being said, the first thing we're going to talk about is not wills. There are actually three documents that I produce for 99% of my clients. And those three documents, and we'll touch on each of them in greater detail, are Advanced Healthcare Directive / Living Wills. Number two is a power of attorney. And then three is the actual will itself. So with the Advanced Care Directive and the Living Will, what that does is it kind of tells the doctors what you want to have done in the event that you can't speak for yourself. And typically, if you're going to be terminally ill, in a vegetative state, brain dead, no chance of coming back, and you're telling the doctor basically, listen, I don't want any superhuman efforts to resuscitate me. No paddles, no ventilation. And again, this is just terminally ill. And just to lighten up the conversation, many years ago, before I went to law school, my aunt passed away, and her husband, my uncle, didn't care for doctors very much. It wasn't that he didn't care for doctors, he didn't like paying for doctors. So, as you can imagine, terminally ill, there were quite a few bills that came in after my aunt passed away. So he heard about this thing, the living will, and to paraphrase his explanation of it, I want them to pull a plug. I'm not paying these doctors, just to keep me in a vegetative state. So I said, no problem, monk. And I did it for him. And I started reading what he was going to sign, the healthcare directive. And as I'm looking out the corner of my eye, I could see his face dropping, like, what am I getting myself into? So I stopped and I said, you understand, you don't have to do this. This is totally optional. This just says, in case I'm terminally ill and there's no chance of recovery and I'm in a coma, don't do anything special. Pull the life-sustaining instruments, the ventilation, whatever. I don't want to deal with it. And he's still thinking. I said, or you could lay there and let the doctors run up the bills. He said, bleep them. Give me this thing to sign. I'm not paying those doctors either. So I executed it. And so the first part of that is to tell the doctors what you want to have done. The second part is probably more important, in my opinion, because the first part, chances are, if you're in that state, they're not going to really try, unless they're really money hungry, to keep you around and have somebody pay the bill. The second part of this is the living will, or the healthcare proxy. And that is basically you're appointing someone to make decisions for you in the event that you cannot. So an example, you don't have to be terminally ill. Maybe you have Alzheimer's. As we get older, the more and more the population's getting and succumbing to that disease. You may not have Alzheimer's, but you may have dementia, where, gee, I really can't think of, you forget people's names and so on and so forth. And you really don't want to be left on your own. So you appoint someone to make decisions on your behalf with the doctor. And basically it says, I've spoken to my, spouse or my children. That's typically who you're going to have as your designated individual. So I appoint my spouse to be my healthcare director. And then the alternative, if my spouse is unwilling or unable to perform these duties, then I appoint my child. Okay, so it's always good to have two, and there's two reasons to have two. Number one, your spouse may be in worse condition than you and really can't make the decisions with you. Number two, you want to have somebody that's going to actually fulfill your wishes. And that's why it's always important to talk to the people that you're going to designate to be your healthcare proxy, who's going to speak to the doctor. And it's important for you to tell them.
I'm sorry, just before I forget, that's the one I have. But my reason was, just in case I get into a coma, I don't want to be kept alive. I just want my son to pull the plug if he thinks that that's the best thing, because the doctor says she's going to be a vegetable or she never will be walking, thinking.
Right.
You know what I'm saying?
And that's the important thing, because you basically have to be terminally ill and the doctor has to determine it. And that's not to say that they're going to make you pass away. They're just going to remove the the machines that are keeping you going. And hopefully Mother Nature will take its course and you won't be long for this earth. But it's important to tell your designated individuals, this is your wish. Because sometimes they may say, oh yeah, don't worry, Dad, I'll pull the plug on you. And then the time comes and they have second thoughts. They really don't want to let you go. They don't want the responsibility of saying, gee, but for me, Daddy would still be here.
This is actually very hard. This is a hard decision. I said to my son, once you pull that plug, don't blame yourself and don't live in that guilt state to the rest of your life.
Very important. You don't want them pulling the plug and feeling guilty for the next 20 years.
Yeah.
So you must communicate your wishes with the people you're designating. So that's very important. Let me just make sure I didn't miss anything before we move on from this topic. Okay. What I also do is I'll get 3 healthcare directive / living wills, and I tell them, give one to the person you're designating, another one to the alternate, and the third one I recommend is giving to your primary care physician, and tell them, take a copy of it and have it on record. You could always take the original back in case you need it elsewhere. It's important to give it to those individuals before you need it. God forbid you get into a car accident and they're looking around. They don't know that you put the living will in the safe deposit box at the bank. Doesn't do many people many good having it there. So that's the kind of the important points I wanted to bring about. So the healthcare directive living will tells the world you don't want to be kept alive, and it also appoints someone to make decisions for you in the event you can't, even though you may not be terminally ill.
I have to tell you, Cass, that's what I said to my doctor. I gave him this is already years ago. I gave him a copy, and he looked at me like, what's wrong with you? You're so young, you're giving me this paper? I said, you never know. I can get in a car and who knows what's going to be next? Cannot be predicted.
Yeah, you may want to think about it, you may not want to think about it, but in either event, it's going to happen. The question is going to happen sooner.
Exactly.
It's going to happen later. So it's better to be prepared. That's the key topics to. You should really have the living will and the healthcare proxy. Very important. The other thing we're going to talk about before we get into wills is power of attorney. Okay, so power of attorney basically authorizes some person to act on your behalf. So if I were to make a power of attorney and if I made Grace the individual to be responsible for my business, I would be the principal, and Grace would be the agent. And basically, the principal, me, would be giving the agent the authority to do whatever I could do. I could sue somebody with the power of attorney on behalf of the principal. I could defend lawsuits. I could file tax returns. Something that's very important that sometimes we overlook. We give the agent the ability to gift money on our behalf. And why is that important? We're going to talk about it towards the end of the presentation about inheritance taxes and estate taxes, but mostly inheritance taxes in New Jersey. So what's going to happen is, let's say as a bachelor with no children, the cheapest inheritance tax rate is 11%. And that's if I leave something to my brother. We'll go into further detail. Maybe I'm sitting there on my deathbed and my brother is my power of attorney, says, gee, why should I pay 11% or give it to my niece and pay 15%? I'm going to give money. And you could give, for federal tax purposes, up to $15,000 per year per person. So if I were married, I could give $30,000 away to any one individual. The individual receiving the money, tax-free. They don't pay any income tax on it. And it gets basically the money out of the estate. So I have less of a burden. If I don't have the burden, I'll be gone. But whoever my executor is.
But Cass, if I may, every state is different probably, right? We're just talking about New Jersey.
It's sad to say, but New Jersey is one of the worst case scenarios. We used to have an inheritance tax and an estate tax. We'll talk about the estate tax later, but that's gone away. But basically, if you're a bachelor or bachelorette, whoever you leave your money to, the government's going to get a pretty decent chunk of it. So even if I had $100,000 in cash lying around, what's going to happen is the government, if I leave it to my brother, they're going to take 11% after the first $25,000. If I leave it to anybody but a sibling, a brother or sister, the government's going to get 15% and more as the rates go up. So it's important to think about what you have and who you want to leave it to in a tax efficient way. Okay.
So what to do to not to give them anything at all?
Well, you could give it to me as a gift, and I'll pay the taxes on it. But I'm actually going to talk about that in the back end once I fill you in a little bit better with the taxes.
What about children? Like if you have children, what's the tax on that?
The children, yeah, my assistant Linda asked me a question, what about for children? Well, they're considered a Class A beneficiary, and you could leave an unlimited amount of money to them, and there's no inheritance tax. But we're going to go a little much further into detail once we finished with the will portion.
Yeah, that sounds good, because I'm sure people are very interested in that part.
Nothing perks up someone's interest like talking about money.
Yeah, and everything almost is lately
Yeah,
about money.
that was a good question, Linda. So the power of attorney, again, just to summarize it, it authorized the person the agent that you're given the authority to do anything basically that you as the principal could do. When does it end? When you pass away. So if you have a power of attorney for someone and they passed away, you might as well throw it away, because there's nothing you could do. It ends when the person passes away. Now, there are basically two types of powers of attorney: a general power of attorney or a limited power of attorney. I'm sorry, a general power of attorney or a springing power of attorney. Springing, like think of like a coil spring. The springing power of attorney comes into effect when you're disabled. So if you give somebody a springing power of attorney, yeah, they're your agent, but they can't use it until a doctor deems you incapacitated. You still have to be alive, but maybe you have dementia, maybe you got a broken leg, and for some medical reason that you can't do it yourself. Then it comes into effect. Most practitioners frown on that, because the purpose of having a power of attorney is for you to use it in an emergency. And you don't want to go shopping around for a doctor that's going to certify, yeah, Kaz is disabled. Doctors don't like putting their names on things any more than they have to. So a lot of the seminars I attend, the recommendation is just to go with a general power of attorney. And the general power of attorney is known as a durable power of attorney. You want to have a general, durable power of attorney. And that the general means you could do anything with it. And it's durable, meaning because if you become incapacitated, a coma, Alzheimer's, dementia, any other thing that keeps you from doing it, it's not going to be affected. It's still in full force and effect until you pass away. So it's very important to have that. Now, you got to make sure that you pick somebody that you really, really, really trust with it, because theoretically, they could take that power of attorney, go to the bank or go to your insurance company and change the beneficiaries, take money out. They have a responsibility, a fiduciary responsibility of the agent. They can't act in their own self-interest. So I have one brother, but let's say I had two brothers, and I made brother A my power of attorney. And I said, well, you could gift, okay, to lower my taxes. Well, he can, but if he's going to gift something to himself, he's going to have to gift the equal amount to my other brother in this example. Then he wouldn't be acting selfishly. If he just if he just took the money to himself, then he's violated his fiduciary responsibility and didn't put my interests first. Okay. The other type of general power of attorney is a limited power of attorney. And I use this when I'm doing real estate transactions. Husband and wife are buying or selling a house, let's say, and they both have to sign off on the deed and the ancillary documents. Well, they come in ahead of time. I have all the documents approved. They sign off on it. And then I'll go to the closing with one of the spouses because the other one's out of town or couldn't get off from work. And lo and behold, about 20% of the time, oh, we forgot you have to sign this document too. So I'm sitting there with one spouse and the other one's in Timbuktu. She has that limited power of attorney to sign documents for the purpose of this real estate transaction. So it saved me a lot of heartache, but that's a very specific thing. And that's usually, the attorney will seek to have, you get that done. It's not something you necessarily have to think about. So,
how long is the limitation for it? The time? Is there a time limit when you say limited?
That's a very good question. The question is there any time limit on it? Well, obviously, we know if you pass away, it ends. But let's say all of a sudden, I don't trust my brother anymore, or I don't trust my fiduciary. You have to revoke it. So you have to either get the power of attorney back, or you have to somehow publicize the fact that, Brother Johnny is no longer my agent and the power of attorney has been revoked. And truthfully, I would have to look in the statutes to say how would you go about revoking it publicly for that purpose. But
I have
very
a
good
question. I have a question, Cass.
Yes.
Who should be chosen as an executor? Let's say somebody has 3 sisters, 2 brothers, one is living here, one is there. The third is at home with the parents, but the parents may be not crazy, trusting this one kid. So what do you do?
Well, okay, we're just getting into wills, and that comes under the will. So the power of attorney ends when you revoke it or you pass away. So now, when you pass away, the power of attorney is gone. Now we bring the will into it. And under the will, you're going to designate an executor and most likely an alternate executor. We're going to go through that in much, much greater detail, but that's a good question. I had another question from Linda.
Yes, regarding the limited and the durable general power of attorney. Does the limited power of attorney have the same, like, can they sign, not just sign documents at a closing, but go to the bank and do things like?
So I don't know if you heard, but the question was, with a limited power of attorney, could you have the same authorities as you did in the general power of attorney? And the answer is no. No. It's very limited for you to do one specific thing. Maybe to go to the bank and open up a bank account in your name, and that's all you could do. So that's why it's limited, as opposed to a general allowing you to do really just about anything. And what you can do is, it's in New Jersey statutes, banking power, buy and sell real estate, buy and sell stocks. I mean, there's just a myriad of things. But attorneys being anal retentive, for lack of a better word, we're gonna list just about everything you could do, even though it's already in the statute. So very good questions. So moving forward to the wills, unless there's anything else, the question becomes, well, who could make a will? And in New Jersey and most states, you have to be at least 18 years of age. And you have to, there's a couple of tests. You have to know who your family is, or who the natural people would be to receive under your will. So you want to know you have 3 kids and not 4 kids. You want to know you're married as opposed to single. So you have to know generally who your next of kin are. Okay.
And
then you have to know what
you're saying this, I'm sorry, because you don't want anybody later contesting the will, right? Sure.
You have to, otherwise, let's say I have 3 children and I name 2 of my children and I'm silent about the third. Well, the third one's going to come and say, hey, Kazzy had the screw loose, otherwise there's no way he would have left me out of the will. I was his favorite child. Okay, so that's why, and I was on the phone this morning with an 83-year-old woman that I've never met before, which raises kind of some red flags because I don't know how they are naturally. So I started off the conversation. Oh, Susie Smith. Could you spell your name for me, Susie? Sure, spell it. How about Smith? How spells it? And where do you live? I live on such and such street in Wayne, New Jersey. Yes, okay. What number is the house? Oh, 234. So now I'm getting levels of comfort that she knows what's going on. Any children? No. You never had any children? No. Okay. You didn't have one, they passed away, or no grandchildren? No, I've been married. My husband died 30 years ago. We never had any children. Okay. So who's left? Well, I have a sister, so-and-so. So, okay. And that's all she mentioned. I said, what about anybody else? Any brothers, sisters? Oh, I do have 2 more sisters. Okay, then that's good. That's important. Now she knows, the universe of the family. Well, what do you have? Well, I own a house with my mother. Okay. Well, is your mother still alive? I said, as long as she's alive. Oh, she died years ago, but the mother's still on the deed in the house. So now we have to, well, what do you want to have happen? Oh, I want to give it to my one sister that still lives with me. I said, okay, that's fine. Now she could do that through her will, but remember we said there's an 11% rate on giving money to your brothers and sisters after the first 25,000. So I did a quick calculation of what the house is worth and how much 11% would be after the first 25,000. And I said, it's like $16,000 that she would have to pay an inheritance tax when she passed away. And this woman, the baby sister, is 72 years old. So now there's a question, are they able to come up with a tax for that? So I'm kicking around some ideas of maybe giving the sister half the house now, which would save about $8,000 in taxes, or giving the sister the entire house and retaining what's known as a life estate, which gives my client the right to live there for the rest of her life. And when she passes, the house would automatically go to the sister. And if she lived long enough, my client, I think 3 years, they would get the house basically inheritance tax free. But so you have to know who your family is, who you want to leave it to, because the worst thing you could do, and this happened to me one time, I found the client and they said, oh, I want to leave everything to my son and my daughter. Okay. And then we're talking, and then another son comes up and say, wait, how many kids do you have? I have 3. You only told me about 2. He goes, I know, but he has enough money. I don't want to give him anything. He's super wealthy. That's all well and good, and we can make provisions for that. But if you didn't tell me, he may come out of the woodwork, excuse me, and say, hey, $1 million isn't enough. I want a third of what mommy has left over. So if that's the case, we put a very simple line. I have 3 children, A, B, and C. For reasons best known to me, I am intentionally not leaving anything to child number C. You don't have to say, because he's terrible, because he forgot my birthday 10 years ago. You don't have to give any explanations, but you do have to, recognize him as being one of the bounties of your affection. Excuse me 1 second.
Cass, I have to say that I don't know how it's going to be later heard on YouTube, but is it possible that you too close to a microphone? I hear kind of, just want to make sure that it's going to be later.
Powering off.
Can you hear me now?
Now it's better.
I can't hear you. What I'll do.
Powering on.
You can speak. You can speak. Yeah, I don't know what you hear or not, but where I sit, I hear this cricket noise, crickling, like in a fireplace, and that's why I'm trying to make sure that you're gonna have the best audio experience listening, because these messages are so important, such a great information, and such a professional. Okay, speaks. Keep talking.
Can you hear me?
Yeah, I hear you well.
Well, yeah.
You know what? Let's keep going. If you hear me,
Okay.
that's okay. That's okay.
No,
That's
no.
fine. Because I hear you really well. It's just I thought maybe something is too close. Sometimes you know how it goes. The same thing with my microphone.
How's this any better?
No, it's good. Now it's better, actually.
Okay, I reduced the volume on my little speaker. So,
Okay.
All right. So now we're talking about wills, and you could, a lot of times the question is, who do you have to give it to? You don't have to give anything to anyone except your spouse. So say you have 3 children and all 3 are super wealthy or super annoying, and you don't want to give them anything. You don't have to give them the children anything. You could say, I've intentionally.
I'm sorry, Cass. Isn't this like automatic thing that, let's say somebody dies and now half goes to the spouse and the other half to the 3 children?
That's called intestacy. That's if you die without a will. Are you talking about that?
Oh, okay.
And we're going to talk about that in pretty good detail. So when you pass away, if you don't have a will and you pass away, the state of New Jersey is going to tell you who gets what.
But let's say you single. Oh, you single, that's another story. But let's say I'm single and I have only 1 child. Can I assume that all what I have will go automatically to him?
You can. Absolutely. But you'll see sometimes it gets a little complicated. And I'm of the opinion you should have a will even if you don't own anything. And the reason is, because you're going to have you want to appoint an executor, okay? If you don't appoint an executor and you have 2 children, well, they could fight one against the other, or they could do it jointly, so. And then there's also something called a surety bond in your will. If you don't have a will, or if you do have a will and you don't make, say, provisions, any executor does not have to obtain a surety bond in this or any other jurisdiction. And that's important. A surety bond kind of guarantees if you screw up and you run away with the money, well, the surety is going to come up and make the beneficiaries whole. So, and you won't be able to get what's known as the administrator's papers without that.
Because you know what, that's another good point. You see, we can go now on, because let's say my son didn't know that I have some big debt, God forbid. Now he gets the money and he's happy. And 3 months later, he gets the bills. Now I'm dead. So then what?
Well, the good news is you're dead and you don't have to worry about your creditors.
That's the good news about being dead.
It's kind of, you may want to work out a different payment plan than that. That's kind of a steep price to pay to avoid your bills. But what would happen is whoever you name the executor is not obligated to pay your debt. Okay, so Grace has $1,000 in cash and $10,000 in credit card bills. All right. Well, the credit card company is going to want their money. They can't get it from the executor. He's not obligated to pay. The only thing the credit card company is entitled to, after you pay for Grace's funeral, any outstanding medical bills from her last illness, thank God, the attorney fees, whatever's left, then the credit card company can put a claim on whatever's left and get that.
So if Grace had a house down the shore,
Yep.
or then whatever the debts are, the hospital debt or whatever,
Well,
they come after?
Yeah, it's not that simple as it sounds. What would happen is, let's say you had the $1,000 and a $500,000 house in Lavalette, and you had $10,000 outstanding from the credit card company. Well, the executor is going to say, well, I don't have the cash to pay for it. And he can do one of 2 things. He can negotiate with them, say, instead of giving you $10,000, would you take $2,500? Okay. Well, let's say he doesn't want to give him anything. The credit card company theoretically is entitled to bring a suit against your estate, and that estate would consist of the Lavalette house. So if they went to court, got a judgment, they could attach a lien like another mortgage to the Lavalette house, and when you go to sell it, they're going to get their $10,000 back. Practically speaking, I have never seen that unless you have $100,000 worth of credit card debt. I don't think any credit card company is going to actually pursue it to that extent. No guarantee, but
How about the hospitals?
Well, the house would transfer based upon what your will says or how the asset is titled. So that brings us right back to the next topic under wills.
Okay, I give you the scene now.
So the will, and a lot of people don't realize this, only controls what is in your name alone. Okay, so me not being a bachelor, everything's in my name alone. So my will would control everything unless it's an account that I have a beneficiary on, a payable of death on. If I have life insurance and I name a beneficiary, so I could say, I leave everything to my beloved spouse, Grace, but my life insurance policy has my girlfriend's name on it. Well, guess what? My beloved spouse isn't going to be too thrilled with me because the insurance company is obligated to pay it to the beneficiary as long as she's alive after I pass. So
Oh boy, I already see,
I can see the wheels turning.
But it's possible, right?
Of course, not only is it possible, I'll give you an example of it. My cousin, Randy, rest his soul, passed away a couple years ago at the age of 58. And he was married, and we did a will. But what happened was he had a small IRA he opened up for about $3,000 back in the 1980s when IRAs first came out. And guess who he had as the beneficiary?
His girlfriend.
No, his mom.
Oh, I mean like girlfriend from who knows when.
Oh yeah, oh yeah. We're gonna leave it at that. Yeah, but he had his mom's name, and his mom passed away many years before him. So since she passed away, then it went into his estate, and then the will dictated who got it. So that was only $3,000. It could have been $300,000. And he might have said, well, if I don't want my wife to get it, I want my sister to get it. Well, the sister didn't get it because it drops into his estate. And he made provisions for his sister in his will, which I took care of. But if he was just relying on that one account, she would have been out of luck. So very important, not just to talk, and a good estate planning attorney will, in your first meeting with him, ask you to list all your assets. Doesn't necessarily care how much those assets are worth, other than for tax planning purposes, but he wants you to know what you have, and just as importantly, check the beneficiary designations. So you don't want to be leaving it to your old girlfriend that you broke up with in sophomore year of college, when you want to leave it to your new girlfriend or your spouse or your children or somebody else. So it's important because they're gonna that contract is going to dictate, and the company, the insurance company, the brokerage company, the bank is going to do whatever that piece of paper says to give it to when you open that account. So it's very important to check that. Okay, so you want to check the beneficiary designations on everything: your insurance, your brokerage account, your IRAs, your 401ks, because it's very, very important to make sure it's going to the people that you want. Now,
with all this stuff that you're saying, Cass, is just like so important that just with that language, with those terms, you dealing with somebody who knows something about this, because I hear so much, hey, you can apply online and you can fill out the form buying a Staples, but it doesn't sound like this is really, that doesn't make sense. It's not reliable.
Probably the cheapest thing you could do with a lawyer is a will. Unless you have millions of dollars and you need an entire plan where you're going to shelter massive amounts of money to reduce your tax exposure, a simple "I love you" will shouldn't be more than, I would say, $500 for a couple. And that should include your living will and maybe even a power of attorney. So
and you have peace of mind, which is that's the whole reason in the first place.
You can't put a peace of mind, you can't put a price tag on peace of mind. It's very, very important. It's like having insurance or not having insurance.
Exactly.
So that being said, let's touch a little bit about houses. So on a deed, you could own things by yourself. You could own it with a spouse, and typically with a spouse, it's automatic joint trust with rights of survivorship. So if my house on a deed says, Kaz and Jane, husband and wife, well, it's understood when I die, the spouse is going to get the house. Now, you don't always want to do it that way for certain reasons, but husband and wife, you can assume 99% of the time, when one dies, the second one's going to get it automatically. The other forms of ownership, you can have tenants in common. So, and when my dad passed away, it went from the estate to me because I paid my brother's half of the house out and I purchased it from him. But if we both wanted to keep it, say it was rental property, so we would put it in a new deed saying Johnny and Kaz own this as tenants in common, which means instead of jointly with rights of survivorship, where the two of us own it and everything, when one's gone, I got it all. Tenants in common are two separate owners. And the importance of that is when in my will, I can say what I want to have happen with my half, just as my brother could say, this is what I want to have happen in his half. And so you can't control the whole thing. You own one half of the entirety, and you can do with it what you will. You could leave it to them, or you could leave it to your children to take the rental income. But it's a different form of ownership. Now, just to not to get too far in the weeds, but sometimes when New Jersey had an estate tax, which I'll talk about later, you didn't want husband and wife owning everything because the state and inheritance lets you shelter a certain amount from the estate tax, which is no longer with us. But the way things are going, it may come back. So it's important to at least have it in the back of your mind. Instead of husband and wife owning it jointly, the husband owns half and the wife owns half. The purpose of that is, well, now when the first one dies, there's no tax. But when the second one dies, instead of having the entire house as her and having to pay taxes on it, she only has to pay tax theoretically on half the house, which is something I'm thinking about doing with the example I gave earlier, where the woman owned it with her deceased mother and thinking about putting the one sister with her. So it's important to see how everything is titled. So that's, they call that by operation of contract. The contract dictates who gets what.
And that's, again, you need to know. If you don't know, you don't know.
Right, absolutely. And now forget about the inheritance tax. If you can have a modest estate of only $100,000, but you don't want to give everything outright. Okay, so I have three children. 1 and 2 are great. Number 3 is a problem. Spendthrift, he can't hold on to $1. Also, can't hold on to $1. Maybe he has a disability. Maybe he's getting Medicaid. He's on Social Security disability, and he can't have more than $2,000 in his own name. So you want to give him $5,000 and kick him off the assist. What do you do? Well, you could have inside your will a trust. Okay, so in my example, I have 3 fictional children, hopefully fictional. One of them, I said, okay.
Are you sure about that? Are you sure about that? No, I'm joking.
Yeah, no,
You gotta be joking. We cannot be too serious. Come on.
I know. When I first gave this presentation to the local Knights of Columbus, before I started, I said, you know what? I was thinking about this presentation, and this whole presentation could be boiled down into 2 words: death and taxes. And I don't care. To show you how old that presentation, when I first gave it, I said, even Johnny Carson couldn't, make this funny, make these 2, death and taxes, hilarious.
But you mentioned, before I forget, there's something really important. What's the difference between a will and living trust? Because I hear this sometimes, but what's the difference?
A will is a will. It's your last will and testament. It dictates what you want to have done, appoint your executor, and you do that. Living will, it's used often, or it's advertised often on the infomercials to avoid probate. Probate is the process of going and tendering your will to the surrogate in your county where you live, and you're basically publishing your will. The whole world could know what your will is.
Why
The
would you
living
do that?
trust,
Why would,
huh?
why would you do that?
You have no choice. Will is a matter of public record. In fact, I purchased a book that was very interesting. It basically said, it was a list of about 100 different people, almost all of them famous, who published their wills. And they actually put the will provisions in a thing. Like Leona Hemsley left millions of dollars for the care and feeding of her pets. They had one, I forget offhand, I think he was an author or something. He wrote his will on the back of a cocktail napkin, and it was valid, and so they accepted it. And it was a whole bunch of interesting stories. I should have boned up on it and could have provided some things for this.
Which this is interesting, and that brings me to the next question: holographic wills and oral wills. What's the difference? What is what?
Holographic will is a will that you do it in your own handwriting. Because if you go to an attorney, he's going to type up the will, and you're going to sign it, and you're going to have two witnesses, and then you're going to have either the attorney or a notary public taking a statement. And that's important for when you go to the surrogate to submit your will. You want to see, was it signed? Did the person making the will sign it? Was it witnessed by at least two people? And there's now what's called a self-proving affidavit. Before, when you died, and this goes back, I think, to the 1970s or 1980s, I don't have the exact date. When you died, the person, the executor, would have to bring at least one of the witnesses with them to court, to the surrogate, and say, yes, this is my signature, I was the witness, I was there. Okay. Now, it's such a hassle, so there's something called an affidavit, which is basically a sworn statement under oath that says, I was here with the testator, the person making the will. I witnessed it. We were all together. We signed it all at the same time. The testator, the will writer, was at least 18 years of age, of sound mind, and under no undue influence or constraints when he signed this will. And they take and basically rubber stamp it and send it off. Okay.
So is this the same thing with oral? Like in a hospital, you're in a deathbed, and you had an accident. You didn't expect, you don't have a will. Now, can I, in this hospital, say to, I don't know whom, doctor, a nurse, what's my, how this looks like?
It looks like you're gonna have a problem.
No, it looks like I don't have a
you-
problem anymore, maybe.
No, you're free of this world. It's true. What's I've heard of some attorneys videotaping their clients saying, "Listen, this is my last will. I'm signing it here, and I'm of sound mind. And Johnny, I didn't put you in my will because you're a no good scoundrel." And that's kind of frowned upon, because all you're doing is, now the video is open to interpretation. Oh, look, those bright lights are on them. There might be somebody standing behind them, forcing them, this and that. Whereas if you just say, I have intentionally left no provisions for my son, so and so, and this is my last will. Now let them prove otherwise. So as far as oral is concerned, not worth the paper it's written on, shall we say? So, yeah.
Let's go with another one.
That's why you should have the will. So now we talked a little bit about the trusts inside the will. And you brought up the living will. Well, I'm sorry, living trust. Trust could be revocable or irrevocable. Revocable, you could change it willy-nilly, and it just basically gets it out of your name, but it's still going to be subject to inheritance tax. So you're not really, if the purpose is for tax purposes, you're really not solving any problems. It'll be outside of probate, but then so would it be if you've left a bank account with a payable on death, and that's not part of your probate assets. Again, The will only handles your probate assets. Your probate assets are what's in your name alone. So if you have everything you own is jointly titled with a payable on death or beneficiary, done. So now why else would you want to trust inside your will? Well, we talked about your child's disabled and they want to keep the benefits from the government coming. So you put that in the will. Typically we say for his health, education, and welfare. So it'll pay if he needs an operation and it's not going to be covered by Medicaid. You know, you get the operation. You want to like supplement his, income buying magazines and, certain things, or take them out, the money's there for that purpose. Spendthrift, basically, if you have a child or a spouse that can't hold on to $1. So what they'll do is they'll say, listen, instead of giving 1/2 to my spouse or my child, his half is going to go into the Smith Family Trust or Johnny Smith's trust. And you're going to name a trustee, which could be the same as an executor, or it could be a totally different person. So the trustee is the one that takes care of the money. So to this, my spendthrift child, here's your $50,000 in trust. Now he's got to go to the trustee who has ultimate discretion on what he's going to spend that money on. So if the child comes and says, I want my money, I want that $50,000, I want to buy a Porsche. The trustee is going to say, thanks, but you're not getting it. Regardless of what you have to say, you're not going to get it. You want a new suit for a job interview, you want to help, you're behind in the credit cards, I'll give you certain money to pay the credit cards directly to the credit card company or to your landlord, but I'm not giving it to you because you're not trustworthy with it. So that's a way of protecting your child from himself, basically, or your spouse from themselves. Interesting. Obviously, a minor. You don't want your child. If it was silent, the kid at 18, I believe, would have access to whatever he was entitled to. So when you have minor children, you don't want to give it to them to junior straight out. You're going to put it into trust and name a trustee. And the trustee could use that money for junior's college. You want to go to a private high school. If you need an operation, the essentials plus your education and welfare, it could be used for it. But
actually,
junior can't.
It reminds me of a case, and tell me if this has, any resonance here. Anna Nicole Smith, you remember that Playboy woman?
I vaguely remember her.
She actually put in a will all the money, everything for her son Daniel. So he will get some when he's 25, 30, and 35. But we know what happened when he was 20, he died. And in the meantime, she had this 5-month-old Danielle, the little girl, and she never put her in a will. I don't know if she still got the money.
She would be entitled, the little baby would be entitled to some or all of it. Typically what happens when you have a trust like that, you'll make provisions in case the child, and again, just to back up one step. So let's say, okay, the kid graduates college at 22, you've used your money to pay for his education and everything. Now, maybe there's $30,000 left in it, okay? Typically, you'll say, well, he could get 1/3 of it when he's 25. So now he'll take 1/3 of the 30,000. You give him $10,000. Go ahead, here's a taste, enjoy it. Another 1/3 at 30, another 10,000, whatever the account grew to. And at the end of 35, the kid's either going to know what to do with his money or he's not. And you have the rest of it. So, but what happens if Junior passes away when he's 22 instead of 25? Well, a good lawyer would have provisions. In the event Junior passes away before all of the money in this thing is dissipated, it'll go to my remaining children in equal share, or it'll go to my nephew or my niece, or who, just like a will has your beneficiaries, the trust should have the alternate beneficiaries in case the main beneficiary passes away prior to all the money in the trust being.
Isn't this about updating? Let's say you had written your will 5 months ago, but now you moved. It's a different state, and maybe everything looks different. And let's say you got married suddenly. And you
Suddenly, nobody should get married suddenly unless
you
unless you have to make
somebody
provisions for a
and
sip or a
fly to
minor.
Las Vegas once this coronavirus is over, and Elvis Presley's,
Don't forget the
But you know
Poconos.
what-
They still have a thriving newlywed business. I understand.
But you know what I'm saying? Something is changing. How many people really think about updating their will?
Everybody should think about updating will. When would you want to update your will? Well, if you move from New Jersey to another state, your will would still be valid. The question becomes, in New Jersey, you need 2 witnesses. Let's say you go to Florida, and I don't know this to be a fact, but let's say you go to Florida and they want 3 witnesses. Now you could have a little trouble, getting it admitted to probate, but I'm sure it's not going to stop, I'm sure there are workarounds. But that's the important thing. If you're going to move, you may want to think, if you sold your house in New Jersey, maybe your house, maybe your will in New Jersey said, I leave my house at 15 Maple Lane to my nephew. Well, you sold 15 Maple Lane, and you moved to Florida, you moved to some other state. Now your nephew comes in, oh, poor Uncle Kaz died. Where's 15 Maple Lane? I want my thing. Sorry, nephew, there is no 15 Maple Lane. You got nothing. That's a specific gift.
Yeah, and that's interesting because what happens, let's say you have your will, then you move to another state, you're getting married, and you have no children, but she has children. So now you have stepchildren. So how that works? Like, then what happens?
Well, remember what I said. You can write anybody out of the will except your spouse. And your spouse isn't entitled to everything. You could really squeeze what your spouse gets in your will, and you could put it in a trust, so it's even harder for her to get at it. So a good lawyer could always have enough strings attached, but your stepchildren, just like your natural born children, have no right to your will. You don't have to give them anything. You could write them out of the will. In fact, I just went to a seminar, and I'm dealing with somebody had a second marriage, and the only asset they had was the condominium they lived in, and it was jointly. So the spouse now owns 100% of it. She had 5 children from her first marriage. The other guy had 8 children from his first marriage. So you're talking about 14 people. And I asked the question, I kind of thought I knew the answer. And I was correct, but I was glad I checked. I said, do you have to name the stepchildren to exclude them from the will? Excuse me. And the answer was, no, the stepchildren were not entitled to anything. Okay. If the only asset was tendered over to the spouse, because then the husband had no estate. Everything went by operational law to the spouse. But he said, I still would put, I'd mention them in the will, the 8 stepchildren, say, I've intentionally made no provisions for you in this will. It's overkill, but better overkill than underkill.
Yeah, so they're not gonna contest the will because the law says if somebody doesn't put them in a will, thank you very much.
Hey, this is a litigious society. Anybody could sue anybody for anything.
Oh, they can sue, they may sue, but if they will win, that's that's the question.
Exactly. But that's the way it is. You're bringing up so many things that I are in my notes, and you're pushing me forward. But that's okay. I go at my own pace, as any boss I ever had could tell you. Why else would you want to trust in your will? To protect your bloodline. So let's say I'm married and I have children, and I have no problem giving everything to my wife, but she's still young and very pretty. That's why I married her. Now, what's to prevent her from getting remarried and leaving everything to the new house and the new spouse. Similarly, excuse me, in that example, there wasn't much except for the condo and the 8 kids he had and the 4 kids she had, or 5 kids she had. If he had a lot of money and he wanted to protect her, his children, he would have to put his portion of his into a trust. Says, okay, I know she's going to take it and give it to her kids, but here's my portion in my trust for my children. Okay. So that's all, they call it like a bloodline estate. Okay. Your internet connection is unavailable. Okay. I guess it's good. It's good. So that's a bloodline. We talked about the minors, the disabled.
How about the joint wills? The joint wills. Did you speak about it?
It's you almost never see it. A joint will is like a husband and wife will. I love you, you love me. I die, you get everything. He dies, he gets everything. You don't really see that. Now you have separate wills. It accomplishes the same purpose, but you know, you'll have to prove the first one died for the second one to probate. It's just not worth the effort. It's just not done, you know. It's like eating the entree before the appetizer. You know, there's no reason for it.
Although some say that we should always start with the chocolate dessert.
They say candy's dandy, but they also told me liquor is quicker. But everyone who's going to view this video is over the age of 18, so I can't be responsible.
No, we're behaving. We are 2 big jokers. We love to joke, but you know, it's serious. It's serious. But you know what? When you dead, you dead. So, and that brings me to another thing, you know, another point. Who should be concerned? Actually, they both should be. Everybody should be concerned, the whole family.
Yeah. Oh, for the will?
Yeah.
Absolutely. Before we get off the wills totally, I want to tell you about a little provision I put in my wills. And basically says there may or may not be a handwritten note or a memorandum folded in with this will. It's not attached to the will. It's a separate sheet of paper. You just keep it with the will. And basically says, you know, I, Jane Doe, made my will on June 1st, you know, in 2020. And in accordance with that will, I want the following personal property to be distributed. I want my Rolex watch, which one? It's just, you don't say, I don't want, you're not going to give them money. You can't give them money. But your personal property, your jewelry, your clothing, your record collection, your book collection, your artwork, whatever you want. I did one where the woman had like 100 Hummels, and she won. I think the one that got the most was like 5. So there are 20 different things. You know, I ended up charging her accordingly, which was still probably not more than, you know, still less than it was worth. And at the end, nobody wanted the Hummels anyway. You know, so one man's trash is another man's treasure, but similarly, one man's treasure is another man's trash. You know, but you could the benefit of doing this, the memorandum in the will, is as your nephews and nieces annoy you and or come into good favor, you could rip that up and change it 1,000,000 times. It has no effect on no will. So all of a sudden, you know, I don't like the boyfriend my niece is seeing. I don't want to give her this watch. And you can change it as many times as you want until obviously you're dead. Then you can't you know, do
And it's
anything
the
after
end
that.
of the problems.
Problem solved.
Yes, we did
Again,
something
that's a
cheap.
tough way to solve your problems, but it works.
Yeah.
So also, so under the will, you could have 3 types of fiduciaries. The one that everybody has or needs is the executor. That's the person that's going to carry out your wishes and take care of the estate. You know, typically it's my spouse. If she's unable or unwilling, then my two children jointly, or one children and the other children.
And
You know,
I'm sorry, because this is another problem sometimes. Let's say it's 5 children,
mhm,
and the parent is appointing one of them.
mhm.
So now it's 4 others, and 2 of them doesn't like that executor at all, doesn't trust that person, and then what?
Well, don't forget, like your agent under the power of attorney we talked about previously, the executor is a fiduciary too, and he can't, you know, finagle his way into more money by power of being the executor. If it says my 2 children get this and this, and you, the executor, get nothing, the executor gets nothing. Now, you wouldn't pick an executor that you're writing out of the will to be the executor, but it's, you know, he has an obligation. And you know, the other 2 could say, hey, I want an accounting. I want to see what daddy had when he died. You know, who got what, where is it is now, how is this being split up? So there's a lot of responsibility being an executor. And I'll tell you a case where, let's just say a relative that I knew was the last of 8 children. And I begged her, I said, Aunt, let me do a will for you. Please let me do a will. And, you know, sometimes people are funny. They think I wrote a will, now I'm going to drop dead. It doesn't work like that. But, you know, I said, listen, here, forget about the will. Let's do a living will, at least, so this way, you know, somebody could talk to the doctor on your own behalf. So I sent an attorney to see her, and he basically said, I'm sorry, I can't, you know, she's not qualified to even do a living will because she's confused. She doesn't know, you know, what's going on, and it just couldn't be done. I said, thank you very much. Well, she passes away, and guess what? About 5 or 10 days after she passes away, well, actually before that, we had a relative that was questionable. So I filed what's known as a caveat, basically a thing saying, I'm going to challenge any will that's produced for this decedent, right? And I said, you know, I'm going to challenge it, and I want to have this that goes to the surrogate, and I want to see a copy of whatever the writing is purported to be her last will and testament, because I knew unless this was done 20 years ago, she didn't have the mental capacity to make a will. Well, I didn't hear from the surrogate, So I called up. I said, hey, I filed the caveat, an exemption, a little hold on the estate. I haven't heard, you know, I'd like to get a copy of the will. They said, oh, the person that came in with the will, as soon as I told them you filed this caveat, they picked up the will and their other papers and left, and that was the end of it. So now that brings us perfectly in, well, let me just finish on that, and then now that's going to bring us to intestacy. What happens if you don't have a will, or if the will is thrown out? So the executor is somebody you want to have in charge of your estate once you pass away. They're entitled to a commission. Excuse me. It's usually a pretty good commission. It's 5% of the first 100,000. That's like 10,000 plus 3% after that. It's a sliding scale. So the bigger the estate, the smaller the percentage, but it's still significant. Let's say, you know, you want the one son to be the executor and you have 4 other children. Well, you can say, you know what? I want to limit the commission to 1% or nothing. So this way the other children are entitled to what they're entitled. Or you can say, listen, my son could take the commission, but then that amount is going to be given off the top to each of my 2 other children. So they each get the same. But the executor who got the commission up front has to report it on his tax return as income, because it's not part of it. He earned that a commission on it. Yeah, that's income to you, pal. So it's not to his benefit to take a commission. You're better off just taking it under the will. Okay. So that's the executor. The trustee, remember we said the trust, if your kid's a spendthrift or he's a minor or disabled, you name the trustee to be in charge of that trust. invest the money and to write out the checks to the college or to the doctor, whatever that child needs for the trust. And the last one is, God forbid, is a guardian. You have minor children. You and your wife pass in a common disaster, car accident, plane crash, whatever, fire.
That's a very good point, and most likely happens very often.
Thankfully, enough times where you need to think about it. Okay, before there was the automobile or air travel, nobody died in a common accident unless it was a fire or something like that. But now, things happen. So you want to name a guardian for the child. So naturally, if you have a child, you die, the mother is going to take the child, or vice versa, the father will be. What happens when you go into, at the same time? I just did a will for some friends of mine, and they named the same person as the guardian and the trustee, because remember, minor children, they're not going to get the money when they're today. They're going to get it when they're 20, 25, 30, whatever. So the trustee is in charge of that money in the trust, invest it, and write the checks out accordingly. The guardian is responsible for the daily, to be the guardian of the child, an alternate parent, if you will, or surrogate parent. So it could be the same person or it could be a different person. Typically, it's the same person because you trust them enough with your child.
What if you don't have that?
What's that?
What if you never pointed out anybody as a guardian and suddenly it's 3 little kids? What happens?
Grandma and grandpa, the husband, fight against grandma and grandpa from the wife's side, and it could get ugly and it could get expensive.
And what
maybe
if they all
your
dead?
parents are gone.
What if they all dead?
Well,
and
then
it's no brothers and sisters.
Cousins. You would typically go down the family tree until you found somebody that wants it. But maybe there's nobody there, or maybe the ones that are there don't forget, you got to get qualified by the court. The court has to appoint you the guardian. Even though it's in your will, the guardian, the court may say, this drunk's not getting your kids, So you have to, worst case scenario, I guess, would be a foster home. So you really want to name who's going to be it. And even, either there's nobody that's there, you got a problem.
Parents should actually talk to somebody while they're alive and they doing this will, whatever. And hey, listen, would you consider? So that everybody
you have to talk to them in advance, because just like I said, with the healthcare directive, you want to make sure they know about it. And you want to make sure they're on board with it. What happens if they don't want it? I'll never forget when I first got out of law school, one of my friends from college asked me to do a will. They just had a new child, right? Well, I said, okay, tell me who you want to be the guardian. Tell me who you want to be in charge of the money. All right, we'll get back to you. The kid's like 15 years later, I say, hey, what happened? You're supposed to get back to me. Well, we were pretty sure we wanted my brother and sister-in-law to be the guardians of our children. But then they got children of their own, and we didn't like the way they were raising them. So in effect, they were flying blind without,
So that was the end of that deal.
Exactly. And I was going to do it for free. So,
that's life. You see, that's why I said don't ever assume anything.
Yeah, that's it exactly. Let's talk a little bit about inheritance tax. In New Jersey, there are actually 3 kinds of taxes. Federal estate tax, ESTATE. There was a New Jersey estate tax and a New Jersey inheritance tax. Well, the federal tax right now is 11 million something. So if you died with less than $11 million in change, no matter who you gave it to, there was no federal estate tax. And if you're husband and wife, theoretically, it's double that. It's like 22, 32, whatever thousand, millions of dollars. So federal estate tax purposes for 99.9% of the people is not an issue. But New Jersey has an estate tax, and back when it was originally written, it was $675,000, which nowadays is nothing. If you have a house and a bank account or an IRA, you're over $675,000. And what would happen is you could leave an unlimited amount to your spouse. So even if you had $1 billion, the $1 billion went all to your spouse, no inheritance tax, no estate tax, nothing. The estate tax says, well, regardless of who you're going to give it to, including your children and your grandchildren or your parents, anything over $675,000, you had to pay an estate tax on. In 2017, that $675,000 became $2 million. Good. And then in 2018, January 1st, if you're fortunate to still be alive, the estate tax went away.
Oh, that's the way it should stay for good.
Well, unless you're a lawyer in this business.
You
But
see,
that
good
but
and bad to
remember,
everything, he's good and bad to everything.
trust me, I hate paying taxes just as much as the next person does. But listen, what's going to happen is New Jersey's, like almost every state, especially with the pandemic, is in tight financial needs, and they're looking for revenue. And when the government looks for revenue, they don't call it revenue. It's really called taxes. They could call it user fees. They could use it revenue. It's taxes. And I think, you know, I have no crystal ball, but I wouldn't be surprised if they bring this thing back to the $2 million mark. And so if you husband and wife have $2 million, you got a $600,000, $700,000 home. You have a $300,000, $400,000 IRA. She has a $300,000 IRA. All of a sudden, you're over $2 million. Excuse me. You're over $2 million. And now you have, if the estate tax was back in existence, that's why I said a lot of times when husband and wife owns things jointly, sometimes you want to separate it. So the husband has $1 million and the wife has $1 million. If you separate it, you can say, okay, my wife's not getting my $1 million, it's going into a trust for her benefit. Now the wife dies, she only has one issue, but if you hear in the news, New Jersey institutes, or even if they start talking about instituting an estate tax, and you have more than whatever number they're going to pick, you should be talking to an attorney, because there are things, ways around to double whatever that exemption is. So if it's a $2 million exemption, theoretically, you can make it $4 million for husband and wife. So just file it away in the back of your mind.
So it will be time to update it.
Yeah, 100%. And then I don't think I fully answered when do you update the will. You update the will when there's a life change experience. You got married, you got divorced, you got a kid. Any of those are the three big ones, you know, that you really want to talk and look over your will and say, hey, how did this affect my estate plan? Okay, so that leaves us just the inheritance tax, which is still in effect in New Jersey. The way New Jersey works is they classify it.
That shouldn't be really inheritance tax. Somebody was paying taxes, now he's dropping dead. And what happens exactly? And what happens now?
Well, if you remember, Whoopi Goldberg, not that I watched The View, but she complained about the estate tax. She goes, let me get this straight. I worked my entire life. I got paid. How did I pay? You took, you know, FICA taxes, Social Security and Medicare taxes. You took federal income tax. You took state income tax. Maybe you took New York City income tax. And now I'm left with 49% of the total. I invest it, it grows and grows and grows. Good for me. I dropped dead. Now you want a certain percentage, a third of that, or 11% or 15%. You know, and it is something. Well, I'm an attorney. I'm not I can only tell you the way it is. I can't tell you why it is.
It's a common sense question, like, you know, hello, no matter where we go, you're buying your groceries, gas, whatever you're doing, you're paying taxes. Only two things are certain in this lifetime, right? We know what?
Death
Death
and
and
taxes. But at least I made it educational and entertaining. The government's not going to make it either one. They're going to make it painful because they're the ones you write the check to.
Oh, you know what? It is what it is, but maybe it's gonna change. Everything is changing. You never know what's gonna be next, right?
Never. Nope, nope, nope.
Never, never.
So,
So is anything that you have to add? Yeah?
oh, yeah, we're only halfway done.
The bad news about now, we're gonna end.
No. It's no bad news. Remember we said there were 3 taxes. New Jersey eliminated one. And the other one with the federal government's probably so far, most people don't have to deal with it. But New Jersey still has an inheritance tax. And it affects people mostly like me who don't have a spouse and who don't have children. Because they break it into classes. There's a class A beneficiaries. Who's a class A? Your spouses, your children, your grandchildren, or your parents, your grandparents. So it's like your lineal descendants. It goes up and down the pole, from your grandparents to your parents to your children to your grandchildren. That's class A. They don't pay any inheritance tax. Class B was repealed in 1963. I couldn't even find out who was in class B. Class C is your brothers and sisters and certain brother-in-law, sister-in-law, but let's just say your siblings, your brothers and your sisters. The first $25,000 you give them is inheritance tax free. The next, then it's 11% up to 700,000. I'm sorry. It's 11% up to 1,075,000, and then 16% on anything over 1,000,007. So as you could see, 11% is 11% is 11%. So every dollar you saved and earned, the government's getting 11 cents on to give them to your brothers and sisters. So let's say you wanted to leave everything to your nieces and nephews. You would still, in my opinion, want to give at least $25,000 to each of your brothers and sisters, because that's free money. Uncle Sam or New Jersey doesn't get any part of it. So you might as well give it to them if you have that much. So there's class D. Who's in class D? Who's ever not a class A or C beneficiary. So that's everybody else, your nieces, your nephews, your cousins, the paper boy, anybody. And that's 15% on the first 700,000, and then 16% on anything above that. So, hey, that's 15 cents on the dollar. If I were to leave my niece $1,000, or let's say, we'll do the math easy. If I were to leave my niece $100,000, well, the state of New Jersey is going to get 15,000 of it, which is why a lot of people have been leaving the state of New Jersey, the successful people, because of the estate tax. It's a big bite if you're not leaving it to. Well, that's one of the reasons they repealed the estate tax, because in that example, there's no inheritance for children or grandchildren. But let's say in 2016, my dad passed away with $1 million, let's say for round numbers. We didn't have to pay any inheritance tax, but the estate tax was still in existence. So the amount between 675,000 and 1 million in this example, you're gonna have to pay estate tax on. And that worked out. Even my dad didn't have $1 million, but shame on me, we had to write a check for $22,000 to the state of New Jersey. I'll never forget the number because I'm never gonna do that again. And what happened was my dad passed away a little over a year after my mom did. And my mom passed away unexpectedly. My mom passed away in her sleep, and we didn't see it coming. And we were such in shock that my dad went and we really didn't give much thought. I didn't do his will. He did it when I was still a minor. But shame on me. It's the shoemaker's son who has holes in a classroom in their shoes. Shoemaker's son. So cautionary tale: if the estate tax comes back, pay attention. Okay. And then finally, class E beneficiaries. Those are charities. And they don't, New Jersey has no inheritance tax. So if you leave $1 million to my alma mater, University of Scranton, or the church, or any legitimate charity, no inheritance tax.
That's interesting, because you know what? Some people really have nobody. Brigitte Bardot, I think she left all her money to the cats. She had 50 cats, from I remember. How that goes? The cats cannot pay the taxes.
Well, they would have had to put it into a trust for the cat. And if she lived in New Jersey, if she didn't live in New Jersey, it's not an issue for the inheritance tax, maybe for the estate tax. I think she was a citizen of France anyway, no?
Yeah, but you know,
Brigitte Bardot.
that Brigitte Bardot.
So I think what happens, France took everything and gave the cat like, a nice dish.
No, because you know that the thing is that not everybody have spouses or children or even brothers and sisters. They have no siblings. And then
Right.
what? You know?
Well, yeah, I mean, the workarounds could be an irrevocable trust, you could transfer some or a lot of your property into the irrevocable trust, but then you have to appoint a trustee. And then every time I wanted to go out for a beer, I'd have to ask the trustee for $10 to go to the bar. So there's always strings attached with everything. But in my example, I left my alma mater, University of Scranton, 10% of my IRA. And it was good for me because I don't think I would have gotten where I am in life without the University of Scranton.
Love you,
Advertising.
Scranton University.
Oh, you. So there, and I intentionally, instead of giving them money outside of my IRA, I intentionally gave them a percentage of my IRA because let's say I give my brother 90% of it. Well, whatever is in there, he's going to have to pay inheritance tax on. And then when the money comes out, he's going to have to pay income tax on. So by taking the money out of my IRA to give to the charity, that's 10% that doesn't get included. And they don't have to, obviously the charity doesn't pay any tax on it anyway. So
and how this goes, you live in New Jersey, then Scranton is in Pennsylvania, and then your brother lives in a different state.
right.
And
It doesn't matter.
doesn't matter.
It doesn't matter. You could, as long as it's a registered charity, it won't have to, pay taxes on it, and I won't have to pay inheritance tax on it. My brother lives in Florida, so also, regardless of where you live, even if my brother lived in New Jersey, he would have to pay inheritance tax on it. But once he got the money, he wouldn't forget about my IRA. Let's say I had $1 million in my bank, or 100,000. So New Jersey would get $11,000 of that. He'd get $89,000 of it. But once he got it, that's income tax free. You don't pay income taxes on inheritances. Okay.
Although if he is in Florida and those taxes are a lot lower, and here he pays a lot more because it's New Jersey or New York. You see where I'm going?
Well, yes, but remember, an inheritance tax is different than an income tax. An inheritance tax says, oh, you drop dead. Who are you leaving your money to? Your brother? Oh, we want 11%. Oh, you're leaving it to your niece? We want 15%. Okay, they have to pay that. That's coming off the top. So now they're either sitting with $89,000 or $85,000. But once they get that check from my estate for the $89,000 or the $85,000, they put it in a bank. They don't have to claim it on their federal or state income tax. And in Florida, where my brother lives, there's no state income tax. So that's why a lot of people.
No state.
That's one of the big. No state income tax in Florida. There's a couple states: Texas, Florida, I think New Hampshire. There's like maybe half a dozen that escaped me. But where was I going with this?
That's why New Hampshire is live free or die.
Oh, that's you live free or die. But that's why New Jersey repealed the estate tax, because they were losing so many taxpayers. They're saying, excuse me, why am I have to pay an estate tax on this to New Jersey? I'm going to pick up and move to Florida, or move to just probably, I would say the vast majority of the states repealed their inheritance taxes and the estate taxes. So if you're a billionaire in New Jersey and you have a wife or kids, you don't have to worry about the inheritance tax either.
I tell you, this is
So
so
I think the last,
information, Cass. This is
I
so
know.
much info.
your head hurting yet?
I tell you, I actually, I had my questions and stuff for you. You answered everything. I have no more questions.
This is pretty interesting, and it'll be quick, but I think it's a good to know in the back of your mind. Maybe this will prod some people to write a will who don't have a will. And so the question becomes, what happens if you don't have a will? Or in my case, with my aunt, we got the will tossed out. Well, and the intestacy laws kick in. And basically the state of New Jersey says who gets what from your estate. So in my aunt's case, a nephew that she hadn't seen in about 50 years got the biggest share of it. And I know my aunt is rolling over in her grave, but I begged her, I said, listen, you don't have to give me anything, but I know this is going to be a problem when you pass away. And so I guess it's not a problem for her anymore.
Yeah, you know what? These people, because normally I have to say, we think parents, one of them dies, okay, is getting whatever is getting, the rest of the kids, or the parent, the second is dying, and everybody should get equal share. That's how we're raised. So if it's 4 children, it's even unthinkable that one of them will get less. It's a hatred. It's a war, man.
Well, that's the reason everybody's go out and earn their own keep and have your own pile.
But
let's talk.
Yeah, okay, go ahead.
For intestacy, that means what happens when you don't have a will or your will gets thrown out. So if you die, and I'm reading this because it's I didn't commit it to memory, but if you die and you have no spouse, but you do have children, the children get everything in equal shares. Even the one that's a spendthrift, even the one that has a disability, you could disclaim it for the child with a disability, but they're going to get everything equally, whatever's left over. So now what happens if you die, but you have a spouse and no kids or no parents? So it's just you and the spouse, and you die. The spouse gets 100% of it. She gets everything. If you die and you have a spouse and you have common children, okay? So husband and wife die. They have 2 children, both from the husband and wife. The spouse gets everything. But what's happening now is there's a lot of blended marriages. Remember the example I had where he had 8 and she had 5? Well, what happens more typically, you have 1 and she has 2 into the marriage. So if you were to pass away with the spouse and you had kids in, let's say you pumped out a 4th one jointly. So if you have the spouse, you have one child together, and then he has children from his previous marriage. The spouse will get the first 25%, minimum of $50,000 up to $200,000, and half the balance. And then all the kids, yours, his, and whatever, would share everything else jointly. Okay, so now if you have a spouse, and actually I'm gonna have to pull this one up. Give me 1 second. So if you have, could you still see and hear me?
Yeah.
Okay, so if you have a spouse and descendants from you and someone other than your spouse, the spouse will still get 25% of your intestate estate between 50,000 minimum and 200,000 maximum, and 1/2 the balance. And the descendants, his children alone, not yours, would get everything else. Let's say you have a spouse and parents, but no children. Well, your parents are going to get part of it too. The spouse gets the same first 200,000 and 3/4 of the balance, but your parents are still going to get 1/4. All right. Parents, but no spouse or descendants, your parents would get everything. So that's typically someone who passes away relatively young, no wife, no children. And then let's say what happens if you have siblings and no spouse. The siblings would take their turn. Now, in the case of my aunt, what happened, she was the last of the Mohicans. So there were, I think, 7 or 8 brothers and sisters that she had. So the estate was divided by however many. So there were 2 relatives that had no children. And with the remaining 5, there was one brother that was deceased had 1 child, a couple had 2 children, a couple had 3 children, and so that was split. So it worked out on a fraction basis. So all the children were split evenly, and then what would happen? They were all passed away. So if there were 5 people left, so and this one only had 1 child, he got 1/5 of the estate. This one had 2 children, so his 1/5 was divided by 2. This one had 3 children, it was divided by 3. So you can see it gets a little complicated, but at the end of the day, you don't want to you don't want the state to dictate who gets what, because in my example, the nephew that hasn't been seen for 50 years got the lion's share.
So let's say it's 5 children, and one is single, the other has a spouse, the third one has 3 children. So the biggest chunk of money will get the one married with 3 children?
No. I die, and I have no spouse and I have no children. I have 3 brothers and sisters, the way I understand your example. Well, if all 3 are alive, this one's going to get 1/3, this one gets 1/3, this one gets 1/3. What happens if this one dies, but he leaves children?
That's right.
So he's going to get 1/3, this one's going to get 1/3, and this 1/3 passes to his children. So if there's only 1 child, if there's only 1 niece or nephew, that niece or nephew is going to get 1/3. If there's 2 nieces or nephews from this brother or sister, they're going to get 1/6, so on and so on and so on. Okay.
Now I understand. I tell you, it's good to know. I'm so grateful. Now tell everybody where to find you, because you're the best, you're the best.
Probably the easiest way, because as you could hear, I don't always answer my phones when they ring, via email, I guess. And it's my name, CASSONDEY @yahoo.com.
Which I'm gonna put in the comment area, your email address. You don't want any phones, no?
I prefer not to, because
Okay.
what's going to happen is somebody's going to call me with a long, complicated question, but if they're forced to reduce it to writing, I can understand, and then there shouldn't be any miscommunications. This way, I read what they asked, and because my fear is they asked me question A and I answered question A, but they really thought they were asking question B, and so, oh, your answer was wrong. So I much prefer in writing.
Okay, so that's exactly what I'm gonna do under this video and everywhere else. It's gonna be the first, whatever you're gonna say, it's gonna be the email. And you can write, and that's it. And the rest.
I'll be happy to answer any questions that I'm capable of answering. If I have 100% certainty in the answer, I'm going to answer it. If I say, I never saw that, I'll do a little research, but then I may refer it out. But whatever, the only thing I ask is, if it's from another state, unless it's a more general question, I won't be able to give you state specific like I could in New Jersey. But ask the questions anyway. Always happy to make new friends.
Absolutely. So thank you very, very much.
The pleasure was mine.
To Linda for her questions. And
Linda works till 3:30. She was done at 3:31.
It's so good. It's always good to see you, Cass. Thank you for all this information. And
Pleasure was
hopefully
mine.
next time we're gonna have more fun. You promised me you're gonna tell some stories.
Yes, some more stories, which are always the most entertaining. It'll be a lot quicker seminar, but it'll be really interesting.
Yes, I'm sure it's gonna be interesting because people are interesting, right?
At least that's a very good way to describe them for sure. People are interesting.
Okay, so thank you, thank you. Have a wonderful evening, everybody, and also you, Cass, and see you next time.
Pop pop.
Bye-bye.